Hello everyone, today's presentation is called Top 10 Things to Know When Defending a Lawsuit. The first thing, it's important to timely respond to the lawsuit. A lawsuit once served on the defendant will require the defendant to respond within a certain amount of days. By not timely responding, the defendant can be in default. This will prejudice the ability to properly defend the action. If the defendant did not timely respond and they are in default, they will have to vacate, which means to overturn the default. This will be done by one of two ways. Either your attorney will be able to convince your adversary to stipulate and agree to vacate the default, and if that does not work, then your attorney will have to make a motion to vacate the default. To vacate the default by motion, your attorney will have to convince the judge that you have a justifiable excuse, which means that you have a good reason for not timely responding, and that you have a meritorious defense to the action, that you have a good legal defense to the lawsuit. Your attorney will be submitting a legal document called an answer in response to the lawsuit. And that's assuming you're not making a pre-answer motion to dismiss first. You're entitled to make a motion before you put an answer to dismiss the action. And of course, if you prevail, you do not have to put in an answer. The answer should include any relevant legal defense. The failure to include a relevant defense can be very prejudicial to your defense, as you will not be able you'll potentially be barred from raising that defense at a later time. Included in the answer, your attorney can also include counterclaims. Counterclaims are essentially the ability to countersue your adversary. Including all the relevant counterclaims will play an important role in your defense and will potentially give you much needed leverage. It's important to retain an attorney that's experienced in a specific area of law that the lawsuit entails. And expertise in that specific area of law will be critical to formulating the best possible legal strategy. It will also play a major role in your attorney being able to exploit every possible legal tactic to gain an edge, as well as to quickly spot a weakness in your adversary's legal strategy. All lawsuits are limited by statute of limitations. Statute of limitations are time restrictions on the commencement of a lawsuit. They're very strict guidelines, and once the time limit is passed, very often there is no recourse. Your attorney should pay close attention to whether the plaintiff has complied with the deadline, as this can be a very critical defense. When consulting with your lawyer, try to give as much details as possible about the dispute. Very often, a client will come to a lawyer and they'll cherry pick the details to disclose to the lawyer, and they'll make a self-determination on what details are important and what are not. This is not helpful. By being as thorough as possible, your attorney will typically spot a detail that will help your defense and that you might not have recognized that it would be helpful to your case. It's advisable to take lengthy notes about the details of your dispute. A lawsuit could potentially drag on for a few years, and your recollection of the dispute might not be as sharp as time progresses. It is much more helpful to your case, especially if you eventually get called to a deposition, if you have a clear recollection of the details. There will be situations where you have insurance coverage for the specific dispute that you are defending. It's important for you to promptly reach out to your insured to notify them about the lawsuit. Your insurer will retain a lawyer to defend the lawsuit, and failing to timely notify your insurer can result in them denying coverage. Finally, maintain and preserve evidence. A lot of times the details of the lawsuit will be very fact-intensive. By maintaining and preserving as much evidence as you can that relates to the dispute can help your lawyer tremendously. And that can include any sort of communication, whether it be email, text message, letter, or any legal document such as a contract, pictures as well, invoices. All these things can be helpful. Any evidence in your possession can help you potentially build your case and gain leverage in the lawsuit. I hope this presentation was helpful, and have a good day.